Okay, great. Good morning, everyone, and welcome to the fourth presentation in AZNHA's 2020 conference series. My name is Steve Thompson, and I serve on the AZNHA board as a director, and it is my pleasure to welcome you here today, and we thank you very much for joining us. Just a few housekeeping items before we get started. You are all placed on mute to avoid any noise disruptions in the background during the session. You will have the opportunity to ask questions. So during the presentation, if you have questions, go ahead and type them in to the chat feature on your screen, and then we will be answering those questions at the end. And we will be recording this session for your future viewing pleasure. It will be on the AZNHA members only section of the website. After the session ends, it'll be posted there if you want to watch it again or view it again. And before we get started with our featured speaker today, we would like to thank our conference sponsor, our series sponsor, SANDATA, for supporting AZNHA and this series. And I'm going to turn it over to Steve Polito. Steve is SANDATA's Senior Vice President of Provider Sales. And again, Steve, we thank you very much for supporting AZNHA in this series. And Steve, we'll turn it over to you for just a few minutes.
Thank you, Steve. I appreciate that. And if you don't mind, I'm going to go ahead and share a slide very quickly. Okay, can you all see that? Perfect. All right, so good afternoon, everyone. I appreciate the opportunity to speak here. As Steve mentioned, my name is Steve Polito. I'm the Senior Vice President of Provider Sales on the provider team. So we're working with the agencies directly, separate from our payer team. Many of you probably know us as the state's awarded EVV vendor, but hopefully you know we're a member of the association. We're obviously proud to sponsor this series of educational sessions that you all are hosting now. As well as we're also a complete software solution provider for the home healthcare industry. We actually offer revenue cycle management. We have an e-learning component. So we have a very robust provider product offering as well. So as assume everyone's aware, the SANDATA EVV solution is made available through the state, and that's provided at no cost, and obviously meets compliance with the state requirements. That said, there are several agencies that are looking for a complete agency management software to integrate the HR and compliance, the payroll, cash application. Some of you are in multiple lines of business, and you want to bring in all your lines of business, even outside the mandate, into a single solution. So you may have heard the term alternate vendor, which essentially means a third-party system that provider agencies can choose to utilize on their own, and of course is capable of sending the required EVV data up to the state's aggregator. SANDATA actually offers our own alternate vendor solution for the providers looking for a full referral to cash system, as we refer to it. And this is different from the payer issued solution, but for agencies that are interested in purchasing the full option, EVV is included, allowing you to still receive the benefit of no cost EVV as if you were to go through the state program. And obviously you're then only paying for the additional feature functionality. So that solution is called SANDATA Agency Management and includes everything you see here on the screen. So what I referred to earlier as referral to cash. It's a web-based platform that handles all the core operational areas of managing an agency. And for anyone interested in learning more about our alternate vendor solution, if you have questions, you'd like to schedule a demo, etc., my direct contact information is in the bottom right of the screen here. If it's okay, I can also maybe post it in the chat box of the Zoom, because I'm going to stop sharing my screen here in just a second. But would love the opportunity, if anyone's interested, would love the opportunity to connect and discuss what we have to offer. With that, appreciate you allowing me a few minutes to explain our capabilities as an alternate vendor solution in the state of Arizona. Hope you enjoyed today's session, and again, thank you for offering us a few minutes. Steve?
Okay, great. Well, again, thank you, Steve, for sharing that information about SANData. And once again, we really do appreciate your support and SANDATA's support as a sponsor of our series. We couldn't do this without you, so thank you very much. Now we're going to get ready to turn over to our featured speaker. As I mentioned earlier, there will be a short Q&A at the end of the session. So if you have questions as we go along, go ahead and type your questions into the chat box, and we will accumulate those at the end and answer those questions once Toni has completed her presentation. So our presenter today is Toni Brown. Toni has worked with the Arizona Securities Division since 2016 doing investment fraud cases. And prior to that, she was with the Phoenix Police Department for 25 years. And in that role, she specialized in vulnerable adult crimes, such as abuse, neglect, and financial exploitation. Toni also serves on numerous national, state, and local committees and task forces to further the protection of our most vulnerable citizens. And I'm sure we would all agree that as home care providers, we clearly have an interest in protecting our most vulnerable citizens, many of whom are our own clients. So we're really excited to have Toni here today to share her thoughts and remarks with us. And with that, Toni, I will turn things over to you.
Thank you, and I appreciate the opportunity to present to you. And believe me, this is a topic that over the past 15 to 18 years that I've been involved with it has done nothing but continue to grow. And I'm going to bring up my presentation, and I hope that if nothing else, it gives you an opportunity to ask questions and open the door for more opportunities for us to speak about more of these issues. Okay, so first of all, as we were already discussing, as Steve indicated, I have been with the Securities Division since 2016, and what we do here is we investigate the investment fraud. We do it on a state and national level, and it's not. When I first got here, I was thinking it was just going to be a totally separate issue from what I had been used to and not anything to do with vulnerable adults. But in a very short time, I realized that the people who are trying to raise money, they're very much focused on targeting seniors across the country and in Arizona. And most of them in some way are vulnerable or are on in some way are on limited income. So I've fallen right back into doing vulnerable adult type situations here. The Securities Division has implemented a vulnerable adult reporting line that is linked with Adult Protective Services here since I have gotten here, and I'm very proud of the fact that we have implemented that. The rest of the information that is up there, the National Association of Bunco Investigators is a group that focuses on fraud, in particular the transient criminal groups. Most people refer to them as gypsies, travelers, those types of criminal working groups, but they also are the Nigerians. They're the people that are calling, saying you won the lottery, the Spanish lottery, the Nigerian lottery, the El Gordo, any of the mail-in fraud that is taking place across the country. So that organization I've been with since approximately 2000. Well, actually, I first got involved with them in 1999, but I've been with them since about 2000. I am also a nationally recognized subject matter expert on vulnerable adult crimes and forensic interviewing of persons with disabilities. So what I'd like to discuss with you today is first recognizing the signs and symptoms of what is abuse, neglect, and exploitation. and recognizing it in clients, recognizing it in the family, the friends, and the extended caregivers of your clients, and also recognizing it in your employees. And your employees may not realize what they're seeing, but how you can pick up on what they're seeing by their comments and their actions and realize that they may be seeing something that they need to tell you about. So it might be a training issue. I also want to discuss how to document those occurrences, how to safeguard your clients, how to safeguard your employees, and how to safeguard your business to protect from complaints, how to protect from incidents coming back to affect your business. And lastly, I'd like to discuss how to know when to report an incident and who to report it to, because mandatory reporting is a big issue. There's mainly 3 types of reporting. One is reporting to Adult Protective Services. Second is reporting to the police non-emergency number. Third is reporting to the police in a emergency 911 situation. And then I'm also going to cover the 2009 Elder Justice Act. Now, the Elder Justice Act pertains mainly to skilled nursing facilities, but I will cover how it does affect or could affect your employees also in a limited capacity. So I just want to throw that in there. Okay, so a lot of people think if they make a bad decision, that means they're vulnerable. Well, not necessarily. And, I have had people that have called me up, and in particular, I had a woman who was a double PhD, extremely smart, extremely knowledgeable woman. She was probably as far from being a vulnerable adult as I could come. And she literally called me up saying she wanted to make a vulnerable adult report because she had made a bad investment decision. She had given money to a neighbor who was going to make some big company decision, and to make everyone rich, and it turned out to be a bad decision. Well, I'm sorry, but that does not qualify as a vulnerable adult. I have had people call me up saying that they're getting the bad end of a divorce situation. Well, that does not qualify you as a vulnerable adult either. Now, get rich schemes. Get rich schemes as in like an investment scheme. Sometimes they may be vulnerable adults. We have actually gone back and contacted investors who, just within the first 30 seconds of talking to them on the phone, I realize they have no cognitive ability to understand what they just sent money to. And we have all seen that. They send money off to charities. They send money off to people who claim to be grandchildren. And it does qualify as a vulnerable adult. Okay, so let's just very quickly, I want to give you a definition. And these are legal definitions. You don't need to write these down. You will have these slides to refer to, but it's good to know what the definitions are. So the definition of a vulnerable adult, according to Arizona's laws, is a person, a vulnerable adult, or an incapacitated adult. There's 2 different definitions. Vulnerable adult is anyone who is 18 years of age or older, who is unable to protect himself from abuse, neglect, or exploitation by others because of a physical or mental impairment. Now you notice it says by others. So self-neglect is not included in there. A lot of people are self-neglectors. And yes, that is a problem. It is something they need social assistance for, but it is not a criminal matter. An incapacitated adult. Now, an incapacitated adult is also a vulnerable adult, but it varies and it's a little more descriptive in what the definition is. Now, it's also an adult, and it's also, but it defines it as by reason of mental illness, deficiency, mental disorder, physical illness. So it can be temporary. Say they're in the hospital and they're in a coma. For that time only that they're in the hospital and they're incapacitated in a coma, they are considered an incapacitated vulnerable adult. Now, if they wake up from the coma and they're perfectly fine, then they're no longer a vulnerable adult. It's not a lifelong, or from the minute you become a vulnerable adult, from that point on, you're never normal again. That's why they came up with this definition. So it can be a temporary situation. Now, they've also included in here chronic drug use, chronic intoxication. That goes to a lot of the population. However, we also have situations where there are chronic alcoholics, chronic drug users who are perfectly functioning. And if you did not know they were alcoholics and drug addicts, you would not know that they were not able to function in normal society. So it's kind of a double-edged sword here. We have case by case where it has to be evaluated as to, at the time the incident occurred, were they incapacitated or not? So it's the definitions are kind of, it can be helpful, or it can not be helpful if depending on when they were incapacitated. Okay, so the definitions, when it says that they is when it affects them, is when they were able to protect themselves. So at the time that the crime occurred, or at the time when they were abused, neglected, or the exploitation occurred, were they unable to protect themselves? And by protect themselves, the courts have come to the understanding that that means, were they unable to pick up a phone and ask for help? Were they unable to get assistance? Were they unable to get to a neighbor and say, I need help, I'm being abused, I'm being exploited? So in that instance, and it can be something where you have a person who is a paraplegic and he's in a home, but he can't get out of the house and he has no access to a phone. He's unable to get help, even though he's mentally perfectly competent. He's physically disabled and he can't get help. Or you have someone who is got severe dementia and does not understand that they're being abused or neglected, or that they're being exploited. So again, it's case by case basis. And it, again, the definition is to the extent that they lack understanding or capacity. So the law covers both aspects of it. It's not always mental impairment. It can be physical impairment at the same time. And then the very last part where it says concerning his person. His person includes every aspect of care and daily needs, including financial. That was brought up in a case where they said, well, his person means only physical needs. The court said, nope, we disagree. It includes financial needs as well. So that's something that it's not written out in the actual law, but by case law, that has come to be an understanding that is included now. Okay, so vulnerable adult crimes. Emotional abuse is probably the least understood and the least charged because it's very hard to prove. Verbal abuse is obvious when you're calling someone names, when you're demeaning them, when you're making fun of them, when you're making fun of their situation. Nonverbal abuse, nonverbal bullying can be as simple as a person in a wheelchair, and they are in a situation where their caregiver won't let them come into a community area of the home, like the living room or the kitchen. They stand in front of them and block their way, and no, you can't come here. You have to go back to your room. That's a very intimidating action, and it's very emotionally effective on the person. That leads to isolation. Isolation is very demeaning and very emotionally upsetting on a person. Disruptive torment is, I have seen that in a legal case where it is defining, say your caregiver has music blasting constantly so that the client can't sleep, or is constantly doing something that is annoying and irritating and just always disrupting and bothering the client. That is disruptive torment, and they're doing it for that reason. So those type of things are in the one that everyone seems to know is Noriega. When they were trying to get him to come out of his stronghold down in Panama, they played loud music until he finally surrendered. But anyway, that's disruptive torment. Social and religious ridiculing, very, very effective in emotional abuse. The emotional abuse is, as I said, it's very hard to prove. I've only had one successful prosecution in all the time when I was with the police department, and it was a gentleman who put himself up as an instructor for autistic individuals, who said he would help them to learn to be independent and live on their own. And what he was doing is he was using flashcards to help them learn money, to help them learn how to provide change so they could get a job as a clerk or in a store type situation. And every time they got it wrong, he would make them go kneel down in the corner with their head against the wall for a certain amount of time. And if they, got the answer right, then, he would continue on with the lessons. So he was not physically doing anything to hurt them, but emotionally it was very, very effective in intimidating them. And eventually we were able to get an emotional abuse conviction against this gentleman. Okay, so physical abuse. Physical abuse is much more obvious. Hitting, pinching, choking. It leaves marks, indications. It's something that you can see. It's something you can witness. Not that you can't witness emotional abuse, but it's much easier to show in court that it's happening. Some of the ones that are not so obvious are restraints. Tying someone into their bed at night because you don't want them getting up and wandering around. Over medication is a type of physical abuse because you don't want to have to deal with them getting up and moving around. You want to have a quiet shift. So they're over medicating a person. Forced confinement, locking them in their room, or excuse me, or not allowing them to go outside.
I know what it is. My speakers here.
Okay. And obvious physical harm are all of forced feeding, These are all forms of physical abuse. On the opposite side of physical abuse is neglect of care. Neglect of care can be just as harmful and can also be emotionally go along with emotional abuse in failure to feed someone, failure to give them medications, failure to ensure their safety. Example of this would be if someone needs a walker to ambulate and you don't want to have to be there to help them move around, so you hide their walker. You think, okay, if I don't let them have their walker, they won't move around. Well, all that leads to is them falling down a lot because they will try to walk without a walker and they end up falling. Lack of cleanliness in a home is neglect of care, or lack of cleanliness in their person, in the fact that they're not being bathed, their clothes are not being washed, their bedding is not being washed. That's all signs of lack of, of neglect of care. So failure to seek medical care or medical attention. I cannot tell you the number of times we have been called to a care facility or a person's home where we have had a head injury. Obviously, people are not trained medical professionals. They can't see inside someone's head. So all I can tell you is the rule of thumb is if someone falls, even if you say, I don't think they hit their head, I don't think they fell hard enough to break a bone, it doesn't matter. If it's a fall, it should be medical attention. If it's a nurse situation, if it's a urgent care, you know, there's different levels of medical attention. Doesn't have to be a 911 call every time, but failure to seek medical attention is a serious problem, and it's a lot of times is a decision based on money. I'm not going to call because I don't want to have to pay for them to go to the emergency room. I don't want to have to pay for the care bill. And it's quite a big problem that we run into, and people don't realize that that's actually can be charged as a criminal matter if there is an actual intent to avoid seeking medical attention. Okay, so under vulnerable adult abuse and neglect, it's all one criminal code under the state law. And it doesn't just pertain to the person who actually causes the injury. If you'll see here, it says the person who causes a vulnerable adult to suffer injury. Yes, that's the person who actually is causing the injury. And it's having care and custody of a vulnerable adult who causes or permits the person's health to be injured, or permits them to be placed in a position or a situation where their health or it becomes endangered. So this pertains to the situation that your companies find yourself in. If you are the care company and you're sending caregivers into a home and your caregivers see a situation and they don't report it, they are permitting that person to be placed in a situation where they're endangered and they're not reporting it. So it puts some of the burden on the caregivers to notify the company to report that we have a responsibility because they are having the care and custody of the vulnerable adult because you're hired to take care of that person. So just keep that in mind. And it's a little repetitive through all of these next few slides, but just keep that in mind that even though you are not the one causing the injury or you're not the one that's physically there when it happens, you still are under the eyes of the law. There is a permitting the situation to occur. So keep that in mind, that it is very much looked at as not reporting the situation. Okay, and it's same with this is the same code, but it's going with the severity of the injury. This is under an injury likely to produce death or serious physical injury. And again, this is just going by how severe the injury is. And again, it has that same wording, causes or permits the situation to occur. This is a situation with emotional abuse. It's a lesser situation, a lesser quality of a felony, but again, it permits the vulnerable adult to be subjected to emotional abuse. Passive actions can be considered aggressive. That's the standing in their way, just blocking them, not letting them come out of their room. That's a passive action, but it can be seen as aggressive. Nonverbal actions can be intimidating, raised saying anything, like a fist. That you're not saying anything, but you're intimidating. And isolation. Isolation and undue influence are seen as invisible restraints to the person that it's occurring to. Okay, moving on to financial crimes. The normal theft statute is pretty straightforward. It goes by dollar amount. If you steal X amount of dollars, it's a certain class of misdemeanor, and as you get higher and higher, it becomes felony. So under the theft statute is this statute under the Class B, which is theft from a vulnerable adult. And just recently, we have been successful through TASA, which is the Task Force Against Senior Abuse at the Attorney General's office, in getting the state to amend the wording in this part of the statute that it allows. It used to just say that a person knowingly takes control, use, or management of a vulnerable adult's property. Didn't say who took control. Didn't say, it could be a family member. It could be someone who walked in off the street that had never met that person before. Didn't matter. Now there is new wording that says that if there is proof that the person took title management of the property without consideration that that use or control was for the benefit of that vulnerable adult, and that the total transfer of the property was in excess of $10,000. If it's one transfer, if it ends up being multiple transfers, it doesn't matter. If it's the total amount is over 10,000, and the person is a non-relative of the victim, and they've known the person for less than 2 years, it's an aggravating circumstance, and it enhances the sentencing. So now when you have someone who befriends an elderly person, I'm not saying that this is always the case, but say a caregiver comes in, befriends the person, you starts with gifts, loans, and they're not someone that's known them for over 2 years. They're not family. They fall under this category for enhanced sentencing. It can be a neighbor. It can be someone from church that falls into this category, but they now get enhanced sentencing and enhanced where they, before that, they may have gotten probation. Now it's mandatory jail time. So this is a good thing to protect our vulnerable adults. And then it still falls under the same dollar amount as the original theft statute. So that hasn't changed. This goes along with the same thing. Okay, power of attorney statute is in that before it used to say that if a power of attorney was obtained under false pretenses, then the power of attorney was invalid. which kind of left it way open to interpretation, because sometimes you were not able to prove that a power of attorney was obtained under false pretenses. What if it was obtained legitimately, but then it was gone on to be misused after the fact? Well, now it definitely defines that. If an agent who holds a power of attorney for a person, if they use the principal's assets with the intent to deprive the principal, the person that they're holding the power of attorney for, if they use it for their own personal benefit in any way, or they use it to deprive the person in any way, it's theft, plain and simple. You can't use it to give yourself loans. You can't use it to buy yourself gifts. You can't use a power of attorney to give other people gifts or in any way, sign over assets that would benefit other people, like people in your family. You can't make yourself beneficiary on insurance policies or trusts, or make yourself a beneficiary deed so that when the person dies, their house becomes yours. None of that is allowable using a power of attorney. The bottom line is, if you are the agent for someone and you are their power of attorney, you have to use their money for their benefit only. And if anything is not used for their benefit, it has to be spelled out in writing in the power of attorney. And it has to say that my agent is allowed to be paid for acting as my power of attorney, and the amount, or, they're to receive $100 a month for their services, or whatever the agreement is. Okay, so some of the other types of exploitation that I frequently would see is forgery. Signing a client's name on checks, or having the client sign the check, a blank check, and then filling it out for what you want. Not necessarily, the person doesn't know what they're signing the check for, or it's a blank amount, and then filling it in. That's also considered forgery. Identity theft, using the client's information, their date of birth, their social security number, to open an account for your own benefit. That's identity theft. Fraudulent use of a credit card, taking your client's credit card, say to go to the grocery store to buy purchases for the client, and then going, let me get $100 cash back on top of the purchase. That's fraudulent use of a credit card. Or going and making your own purchases for your own benefit. And that is also goes for online or in-person purchases. And then I'm getting some feedback, so somebody's mic is on. Okay. And then fraudulent information to a financial institution. This is when someone will call up and either pretend to be the client, or will do online banking and open up an account in the client's name, or use the client's information and open it up for their own benefit, move clients' money to other accounts, and do online banking. That's fraudulent information to a financial institution. And then fraud schemes or fraudulent schemes is usually an ongoing course of conduct or behavior of wrapping all of those or some of those crimes up above. And it usually will include elements of abuse and neglect wrapped up in with all of that ongoing conduct, especially isolating the client, keeping them from friends and family, because you don't want people to find out what's going on. And I'll get into the isolation issue in just a moment. But if you see any of that where you start seeing that the credit card or the person's debit card or their checkbook isn't in their possession, it's in a family member's possession, it's in a friend's possession, that should be a red flag, because they should not have their financial documents in someone else's possession unless that person is a verified, like their power of attorney, that has a right to have those documents and handle those matters for them. Okay, duty to report, because we run into this quite frequently. People are afraid to be the one to raise the red flag. They're afraid of being retaliated against. They're afraid of retribution. And I'm not saying just being yelled at. People are afraid of actually having someone come to their home and have physical violence against them. And I understand that. I understand completely. But it's a matter of doing the right thing for the right reason. And the law does protect people who are the mandatory reporters. So people who are responsible for the care of an adult, and this also goes for children, but this is just the vulnerable adult reporting statute, that is incapacitated or vulnerable, and they have a reasonable basis to believe that abuse or neglect or exploitation is ongoing, must, and it's not, should, may, it's must report the incident to a police officer or to protective services worker. It can be one or the other. It can be simultaneous to both. It depends on the situation. If the vulnerable adult's safety is at risk, if it's an abuse that's ongoing where they're being injured, or their safety, or you feel that they could possibly be injured, then it's a police issue. If it's a financial exploitation and you don't believe their safety is at risk at that very moment, it can be an adult protective services notification. I will tell you that 99% of the time, adult protective services will report to the police department, but they don't report to the police department until after they are done with their own investigation, which can take 12 to 18 months. So in the back of your minds, keep that thought. Is this a situation where I think it can wait 12 to 18 months before the police get involved? Or do I think the police need to get involved sooner? So keep that in mind when you're trying to decide one or the other on where it should be reported to. Adult Protective Services does not have any arrest or police or criminal charging abilities. Once they do their investigation, they have to turn it over to either the Attorney General's office or to a police agency for criminal charging. So there is a delay there. Just keep that in mind. So failure to report, it's a class 1 misdemeanor. The only time I have ever seen a failure to report being charged was in a unlicensed care home, where a woman owned a home where she had several elderly people living in her home, and her caregivers were coming to her and saying that another caregiver was stealing from the residents. And so we had several witnesses reporting to the management owner what was going on. She told them to keep quiet and do not say anything, and she would take care of it. And she did not take care of it because she thought if the police came, they would find out she was unlicensed, and that would be a problem for her. So she was the only one that I know of that we actually charged because of that line of thought, that thinking that she did not want the police to find out that she was unlicensed. So therefore she was going to let this crime continue. Anyone who does file a complaint is immune from civil or criminal liability for being a reporter. Now, there is a loophole to that. If someone does it with malice, if someone files a false report to get someone else in trouble because they don't like that person, or they want to get somebody in trouble to get them away from, best way I can explain this. Family member is taking care of grandmother. Another family member wants to get in there to get their hands on grandmother, and they want the other family member out of the way. They'll file a false report saying they're doing something wrong to get them in trouble, so they are no longer the caregiver. That's false reporting. Then they could be in trouble for that type of a report. Other than that, the reporter cannot get in trouble for filing a report of abuse or neglect or exploitation. Okay. The Elder Justice Act came out in 2009. It's a federal law. It was designed specifically to cover any long-term care, any nursing care facilities, any assisted living care facilities, it also covers in-home care facilities as long as they accept federal money, federally funded care facilities. So if you have residents who pay their bill with Social Security money, Medicare funds, Medicaid funds, anything along those lines, they are subject to the Elder Justice Act. The Elder Justice Act says that the owner-operator of the facility, they're responsible for making sure that every covered individual in the facility, that means everybody who works there, every employee, every contract worker, every anyone who empties the trash, anyone who comes in to change the light bulbs, anyone who is in that facility that is a contract worker or a paid employee is a mandatory reporter. They are not responsible to tell their boss what they saw. They're not responsible to go to the nearest nurse or manager and tell them what they saw. They themselves are responsible to report what they saw. And what their timing on this is, there's two parts. If they see events happening that cause serious bodily injury, they have to report it within 2 hours. If they see something going on that is not a serious bodily injury, they have 24 hours to report. Now, if that employee does not report, well, let me back up a second. If that employee does report, and that employee is then subject to some type of retribution from management, such as discipline for why did you not tell us, why did you report, and then it's kind of a whistleblower situation. They're protected from any retribution under their law. The civil penalties against the facility are very stiff, up to $10,000 per incident, and it can go up to $200,000 in loss of federal funding. So, of course, all of these care facilities were shocked. They were scared to death they were going to lose their federal funding over every little thing if it didn't get reported. So what we were seeing, and I was, not just myself, but quite a few of the police departments, we were inundated with police reports. Adult Protective Services was inundated with reports for lost socks, broken dentures, broken eye or lost eyeglasses, hearing batteries and stuff being lost, torn blankets, broken wheelchairs. They didn't know what qualified as something they should report. So they were reporting everything to us. They were going by the motto of see something, say something. So what we did is we had to get with Department of Health Services Licensing Division and say, can we come up with a standard of training? So we did a very quick thing on what are the abuse, neglect, and exploitation laws? What do you need to report on? Very similar to what I just covered in these previous slides, because they were panicking over what needs to be reported because they were all afraid they were going to lose their funding. And so after about 6 months, things calmed down quite a bit. So what does that mean for caregivers that go into people's homes? Now, it's my understanding that you don't go into care homes, but do you temporarily go into any facility? Do you ever go into a rehab facility? One of your clients maybe had a fall and you're responsible to go check on them.
Yes, we do, Tony. Assisted living, independent living, and skilled nursing.
Yes, that was my understanding. So the minute you step into that facility, you are a covered individual. So here is where this Elder Justice Act covers you. So you are now any covered individual that comes into there because you fall under caregiver. You are considered a contract worker because you are there to care. And it's in their term for caregiver means any individual who's responsible for the care of an elderly person. It says either voluntarily or by contract. That would cover your employees. And the definition is there. You can read that. So just keep in mind that if your employees go into one of those facilities, even just for like a quick follow-up, then don't expect that if they see something, they can go, oh, I don't have to report it because, I don't work here. This is somebody else's problem. They have the same expectations as they would as the employees do. So just keep in mind that the Elder Justice Act does apply to your employees there. Okay, so when you're going into clients' homes or where you go to the facilities, wherever you're going to, the employees are basically your eyes and ears. Obviously, they're the ones that are the front line. Some of the things, and I'm just going by some of the cases that I had experience with, and I know I probably have a week's worth of examples I could use. I'm just going to pull a few out here. Red marks on the jaw, which usually are an indication of somebody's force feeding. They're prying someone's mouth open to try and force feed somebody, and if your employees are documenting these or telling you these type of things, you may have family members that's a sign of frustration. I can't get them to eat, so I know they have to eat because that's important, so I'm opening their mouth and cramming food in there. Not only is that unsafe because they can be making them and putting them in a choking situation, but keep an eye on those little red marks, fingernail marks, stuff like that. That I already went over the issue of the walker. When your staff members, your caregivers show up, is the client's mobilization aids, walkers, canes, whatever they need, are they placed out of reach of the client or hidden from view? If that's routinely what they see when they show up, then that might be an indication that they are hiding them or keeping them away from the person to try and limit their mobility or to isolate them to keep them from, and that could be, part of a isolation, which is part of emotional abuse as far as keeping them from moving about. And family members that are, if they're trying to always talk for the client. And I know it a lot of times it appears they're being really helpful, trying to answer for the person, but a lot of times they're just trying to keep them from saying what's really going on. They're trying to fill in the blanks, and especially if they won't leave the room. You know, the ones that always insist on being in the room with the busy work and standing by, and they won't let you, you know, talk with the person when they're not right there. It may not seem like intimidation, but just their presence in the room or standing nearby or just suddenly having to shuffle papers on a desk nearby can be very intimidating to a person, and they may not want to tell you what exactly is going on when that person is in the room. So, you know, make note of those things. If they're not allowing you private time with the person or your caregiver private time with them, then that might be an indication that they're trying to keep them from telling what's going on. And another issue, if the client's property comes up missing, checkbook, credit cards, eyeglasses, hearing aids, you know, those things that they need to be able to communicate. And then when an issue is raised of, well, where's your hearing aids? And then suddenly they're found. That's an issue that they're trying to isolate the person or keep them from them. So, you know, they need to document that type of stuff, because they don't just automatically go missing all the time. It's someone's keeping them from them in order to isolate that person, or to, in a checkbook, they may be using the checkbook and trying not to let them see what's going on. And then the client's behavior themselves. If they become quiet, withdrawn, less talkative, sullen, when one particular person is around them, a family member or a neighbor or another caregiver that's you know there, that might be an indication that they are afraid of that person, that they've been warned not to talk by that person. They're intimidated. So these are some indications. It might not be physical abuse. It might be undue influence. It might be a lot of things, but those are some of the indications that you might want to look for, and have your caregivers document that attitude changes, or the fact that the caregiver won't let them stay alone. Let me make sure I didn't skip two. Nope, there we go. Okay. So how do you protect your client? One, if your caregiver, your employee, overhears things or they see these things, you know, it needs to be documented. It needs to be somehow reported in their care notes. So if you overhear a family member saying something to the effect of, well, I had to stand in their way to keep them from going outside. You know, I just stood there until they turned around and went back to their room. Okay, that could be a nonverbal emotional abuse. Maybe they're intimidating them just by standing there. Maybe it is, maybe it isn't. But if it's a repeated pattern, it could be something that you need to document. It's something that should be reported in the care notes for sure. You know, make sure that maybe they know the proper way to explain to the family member that, you know, maybe they should divert them a different way. I would not put in the care notes, I saw them using nonverbal emotional abuse, because that calls for maybe a level of training and diagnosis of what they're seeing that they don't need to be putting in there. But if it continues, and it comes down to Adult Protective Services needing to read those care notes or the police needing to read it, then they will be able to look at that and go, oh, this is a pattern of nonverbal emotional abuse. So you definitely want to put it in there, what they're seeing. Say you see your employee overhears them talking about trying to give an elderly man a bath, and his hands are wandering, and I had to smack his hands. Well, I'm sorry, but smacking is hitting. That's bad. That's abuse. So that definitely needs to be something that needs to be reported, and it needs to be addressed right away. The issue that all these type of comments in these type of situations is this is frustration. The family members, these comments, these little actions are frustration. Frustration is where it begins. There's a triad of actions that lead to abuse, and it starts with good intentions most of the time. Sometimes people take in family members and their underlying intention is, well, I'm going to be the one to take care of my family member, my grandparent, my parents, because I ultimately want the money. I want to be paid for for taking care of them and keep the money. And then they just don't realize how hard it is to actually take care of an elderly parent or a grandparent, how frustrating it can be, how hard the work is. So the frustration builds up, and then the frustration turns to anger. They actually get mad at their family member. They get mad at the client for making them put up with this, for making them do this work. And then the abuse starts, the verbal abuse, maybe the neglect of care. Like, I'm not going to change your diaper today. I'm just going to let you sit in it till tomorrow. And then when that doesn't work, then the physical abuse starts. And then the physical abuse, then they start feeling entitled. Like, damn it, I'm entitled to take your money because look what I have to put up with. So it's a pyramid of actions that builds up. And this is the structure. So when you start seeing these little comments, this being overwhelmed, getting frustrated, then they get angry, and they start with the verbal comments, and they may be expressing some guilt. I can't handle this. I don't know what to do. And then they start bullying or degrading, blaming the victim even. Then they start feeling sorry for themselves. And then it's well, I deserve this, so I'm just going to take it. So keep in mind that it's a building inside. This is all happening internally. And if your caregiver starts seeing this, start hearing these little comments, start seeing this pattern building up, these are things they need to start noticing with family members, so they can start stepping in and saying, okay, maybe we need to get some help for the family. Maybe we need to get some respite care going. We need to maybe get some additional services in here, because this is when the abuse and the exploitation is all going to start. Okay, so your staff is doing the right thing. They're in there, they're taking care of their client, they're documenting what they should. So how do you protect your staff? Documentation is probably the best thing you can do. As management, as behind the scenes, you need to communicate with your staff. You need to have that open door policy. Otherwise, you're not going to really know what's going on. If they're documenting everything they should, and they're not keeping up with you on what they're frustrated about, what's going on, they might be making the appropriate notes, but they're not expressing their frustration on what they're actually seeing going on. So you need to keep that going. So you need to protect your employees so that it doesn't backfire and you end up getting a report against your employees, because if the frustration is building up, they may be getting a report against them at some point, and it may be an unwarranted report where a family member complains against the caregiver because, say, this caregiver sees what's going on in the family and all of a sudden they just snap at them, or they say something and the family's like, oh, that was inappropriate and I'm going to make a report against you for being, rude, or you did something I didn't like. So, or the opposite side, this caregiver suddenly thinks they need to do more to protect this client. Well, they want more shifts with this elderly person because they see what's going on with the family and they want to protect this person. So do they need to step in? Do they need to start going over there off the books? Do they need to start going over there on weekends, on their days off, and you don't know about it? You don't know what's going on? Are they doing stuff off the books? This communication, I was actually surprised to find out how many caregivers do that. They stop over and check on their clients off the books, on weekends, on their days off, because they're that concerned, they're that worried. But if you are aware of it, and I'm not saying that you approve of your employees going over and doing things off the books and working on their own time. But if you have this open line of communication with your employees, if you know when your employees need to work extra shifts or are asking to work extra shifts and why, then when, say, a complaint comes in and you can say, yes, my employees were very concerned about this client. Yes, they came to me. Then it's not a big mystery. It's not a big concern when then a complaint comes in and, say, APS or the police come and you can explain what happened. If it's not approved, if the company's not aware of it, you can be held you can be held liable for your employees' conduct because they're there representing the company when they shouldn't be. So keep that in mind, that you really want your employees doing the right thing. And if they are trying to do the right thing, that's great. But have them do the right thing with your knowledge. If they're there working off the books because maybe they're developing this private friendship with this elderly person and they're maybe doing their own little, building a rapport with them and for maybe exploitation, I don't know, then maybe that's not a good thing and that needs to be addressed in a whole different way. But false complaints do get filed all the time when employees are doing the right thing. If they're not doing the right thing, then obviously that needs to be addressed. Okay, so things to look for when you're starting to see where your employees might be doing things that they shouldn't, but they're showing frustrations. And I'm not accusing any employees, any caregivers of doing things, but we have had instances where employees have been, caregivers have been overwhelmed and have had some issues. So say a caregiver, you overhear one of your caregivers talking and she says that my client is so absent-minded, I had to help her fill out her checks again. Okay, that in itself could or could not be a problem. Another caregiver comments, that lady is a pain in my, I had to give her an extra dose of her sleeping meds just to keep her quiet. That might be more of a serious issue. So are these signs of a helpful employee? Are they being a good employee? Is it signs of frustration? Or is that a future problem? It could be all of the above. It's very likely it could be any one of those. So you want to trust your employees. I would. That's, you're sending them out into people's homes, you're training them, you're giving them the tools they need, but you still need to have some ability to keep an eye on them. But if you have a caregiver who offers to work extra shifts, that's great. The one that fills in for everybody that calls in sick and has needs time off. But if they're always wanting extra shifts with one particular client, that might be a problem. They might be wanting to isolate or influence that one particular victim. They might want to access certain accounts or again, develop a certain friendship with that one client. Do you have a caregiver that offers to work late shifts, nights, weekends? Especially if you have male-female crossover working arrangements, less supervision, less staff on duty, not as much people to keep track of what's going on. That's when most of the physical and sexual abuse takes place. Late, it's either night shifts, weekends, or late shifts. So that might also be an issue. Have you ever had a day shift caregiver show up to replace a night shift caregiver and that person's just not there? And you're wondering, did the night shift caregiver leave early? Did they just not show up? I mean, there's some issues with finding out, did they sign in? Did they say they were there the whole shift? Did they falsify timesheets? So maybe spot checking in the middle of the night to see if the caregiver is actually there. These are some of the things that I've had family members show up and say, I showed up at 11 o'clock at night and there was no caregiver in the house with my elderly parent. So some of these things, these are to protect your business, just to make sure that your caregivers are doing what they need to. And the reason I bring up this last one is, and I'll give you just a quick case scenario, is caregiver loaded up her 3 clients. She was a caregiver in a group home, loaded up her 3 clients, got them out of bed, loaded them into a van, drove them down to her boyfriend's house, left them in the van, locked the van, went in, spent the night with her boyfriend. When the day shift people showed up at the group home, there was nobody there, no clients, no caregivers. And she put out an alert, and we had a missing persons for 3 mentally disabled adults. And we found the van in a parking lot of a industrial warehouse is where she left them. And about not quite a mile away, she walked to her boyfriend's house and she was there with her boyfriend. So again, night shifts, weekends, yeah, it's when the majority of issues occur. So it's always when you should be spot checking. Okay, so how do you protect your business? Employees filling out checks. And if this is part of your business, I don't know if it is, but if you have employees who are designated that is part of their duties, they should be going through some type of financial exploitation training before they are allowed to do that. And if that is part of their duties, they should not be filling out their own paychecks or any checks that are made out to themselves. Anytime you have an employee that is over-medicating or under-medicating a patient, that should be reported immediately because that is serious health concerns and could be affecting the client. We've had caregivers that are substituting other medications for narcotics and stealing the medications for themselves and giving clients medications they're not prescribed but look similar just so they can give them something that's very dangerous. So that should be reported right away. Just a couple of examples there. Reactive versus proactive. And I can tell you from experience that going with Adult Protective Services, and we go to a facility or we go to a business and we walk in, and the look of the deer in the headlights look when it's a company that is not prepared and has no idea that we're there, why we're there. They have no idea of the issue. Definitely a reactive type of a situation. They're scrambling. They don't even have a clue that there's a complaint filed against an employee. They're trying to piece together the paperwork. They don't know where the schedules are. They don't have the client records at hand. They're not even sure what the issue is with the client. They're not sure if there's any other employees that may have witnessed anything. We've got managers that are defensive because obviously they're unprepared. And because they didn't even know there was an issue, they've let employees go home or they're off shift, so we don't have anyone there to speak with. And I can honestly tell you that after a situation like that, you are left with they have no idea what's going on type of a reaction. Okay, so proactive. When a complaint comes in, when the police show up, you've got records, you've documented it. You're like, oh yeah. Let me show you the client's record. Yes, there are red marks on his face that he has a palsy. He needs his face stabilized during or his head stabilized during feeding so that he can eat. We have doctor's records saying that we are allowed to, to help stabilize. Document these things. We have a guy that's very bad with trying to grab the female caregivers. We documented there's 3 incidents during the last week that he tried to grab the caregiver. So this way there's not going to be a complaint where somebody had to, remove his hands or did something inappropriate with the client, because you're documenting that he has a history of behavioral problem in this way. After hours, it's always an issue with trying to obtain care records for the client, because a lot of times the caregivers don't have access to records, even with EMTs coming for the clients if there's a health issue. So those type of things, it's always good to try and be proactive and have those records available if there's a situation. Training, huge part of it. We know that caregivers, sometimes English is not always their first language, but it's always good to make sure that they know their job duties. They know what their work process is. They know what, if the police show up, if Adult Protective Services show up, this is what you do. You don't sit there and say, I don't know. And honestly, I've actually had people say that my boss told me if the police show up, that's what I'm supposed to say, which not a good answer. So, and let your employees know it's okay to call. Let them know that they have the ability to report. They have the ability to be cooperative with the authorities, and it's not a bad thing. Attempting to clean up or alter a scene, if there is like an injury or an accident or something happens, never looks good. It always looks like a cover-up, like you're trying to change the scene. So if something does happen and there is a problem, if there was an accident or if, you know, there's a fall or some, just leave the scene as it is. It doesn't need to be covered up. It doesn't need to be cleaned up. Just leave it as it is and just report it. It always looks better to just leave it as it is and let it be reported for what it is. I have had skilled nursing facilities and long-term care facilities wait 12 hours because they wanted to clean up a particularly bad scene and move a client to a completely different room because they didn't want us to see what actually happened in a room. And it's amazing how bad that looks, not only in a criminal world, but in a civil litigation, and it always comes out. And then probably the last thing I could say is when your employees do something right, reward them, because that's the thing they remember and they'll do it again. They will do the good thing again if they know they get rewarded for doing the right thing. And as a company, and I know you're all organized and you have your organizational groups, but intergovernmental review boards, if you can be a part of those, APS review board, we had a huge group to get together and try and see how we could help APS do their job better. Department of Health Services, we did the same thing. The TASA committee, these you can help to shape how things are done. Intercommunity organizations, you know, if you need to help the community to shape how the government does things, how your industry does things, by all means, the more the merrier. We need as many people helping as possible. And then this I just think is kind of a sign of our times. A few years ago, the big buzzword was the silver tsunami, and we were all just learning how to deal with this influx of huge influx of our seniors, and we were getting a handle on it, learning how to surf the silver tsunami. And then we're like, whoop, wait a minute, what's that? And then there's COVID. So now we're learning how to surf the COVID wave. And hopefully we will survive this. We will all get through it again. And if anyone needs additional training, I am offering up my consulting. I do offer training in vulnerable adult abuse, neglect, financial exploitation, recognizing and documenting and reporting for managers, financial exploitation for caregivers, and abuse and neglect for caregivers, vicarious trauma or compassionate trauma syndrome for caregivers. That's the new big thing that it seems to be. I'm on a national committee to define and identify some toolkits for people to identify vicarious trauma, recognizing stress and the abuse pyramid for caregivers, and interviewing vulnerable adults. So any of those would be available if you are interested. And now if anyone has any questions, I'd be more than happy to take some questions.
All right, so I'm going to start at the top and go down. If anybody else has any questions now that Tony's finished, feel free to put them in the chat box, okay? First one from Steve Thompson. We sometimes find ourselves in situations where we're providing care, but others are involved, family, friends, etc. Please elaborate on our duty to respond report if we see some form of neglect or signs. I think you touched on that already, Toni.
Yeah, it's a very touchy situation because one, they brought you in to provide care, and yet you are kind of doing a collaborative with the family. I understand that it's a situation where if you report that you're seeing the neglect, then the family could just terminate your service because they don't like what you're saying. It could be a learning opportunity. You could be teaching them, so, this is maybe a better way to do things. But I think if it's more of your first responsibility is to the client. And I know that's probably not the best for your business because it might lose you business if you report. It's a very tough situation to be in, unfortunately.
But at the very least, if, let's say we go in and do an assessment from the office, or our caregiver calls and says, hey, I'm concerned about this. At the very least, we could call somebody like APS or the non-emergency police line and run the situation by them and get guidance, correct?
Yes, I would say if at the very least, the first step would be to notify Adult Protective Services. Now, Adult Protective Services has up to 36 hours to assess and to show up. So if it's an immediate concern, again, go to the police as opposed to the Adult Protective Services. I had a situation where a caregiver walked in and a gentleman was supposed to be on a feeding. Actually, he had refused he wanted to was on hospice care. He did not want any feeding tube. He did not want any additional life-saving efforts. His life partner did not agree with that. His life partner wanted him to stay alive, so he went down to a local pet store and he bought some fish tank pump and some tubing, and he developed or kind of put together his own feeding thing, and he was force feeding him with a fish tank pump. And the caregiver walked in and went, oh my goodness, and immediately called the police because he could have killed the guy with this thing. And that was the right move, definitely the right move. So it's definitely a case by case. If it's something you feel needs to be addressed immediately, then police. If it's something you think can wait a 36 hours, 48 hours, then definitely APS.
Okay. What about with powers of attorney that are going to be the heir, and there's kind of, a suspicion for the withholding of spending money because it's their future inheritance? Who should they, I know that's a really sticky one, but, at the very least, documentation is who would be the person, I guess, that we could run a situation like that by?
If the person that is the power of attorney is also like the only family member, or they're definitely the heir to the person's estate, if the person was mentally competent and said, yes, I want this person to be my power of attorney, then it probably would be a good choice for Adult Protective Services to do a financial exploitation investigation. But again, if you've got a situation where that same person has just drained the bank account and there's no money to pay for food or electric or basic needs for the person because they've taken their inheritance early and drained everything, then it's probably an immediate need of services and intervention with the police.
Okay. Zach, this is a tough one. Zach asked, I had a client who was a chronic alcoholic, non-functioning, clinically depressed, and slowly killing themselves with drinking. We called APS 3 times on this individual to report, and 3 times APS didn't do anything to help. We tried admitting them to rehab, but they refused. Multiple times the fire department had come out and they would not take her either. On the last hospitalization, we officially discharged services due to the circumstances. What else can we do in these situations where a client is causing self-harm, won't take help, and we feel like we're reporting, but nothing's being done?
The issue with that is that if the person is living on their own, they're functioning to the point where they're able to like make their own daily decisions as far as paying bills, and they can eat, feed themselves, dress themselves, and granted, maybe their only food source is alcohol because that's their choice, then Adult Protective Services will not step in because they are meeting their own daily living needs. The only other option would be to file a complaint with the Public Fiduciary's office and see if they would file a petition to become an emergency guardian.
Okay.
Because Adult Protective Services will only step in if they are not of sound mind. Well, and again, an alcoholic can or cannot be of sound mind, because if they're a long-term alcoholic, they can be functioning.
Andrea Yarber asked, if APS does not follow through or does not resolve an issue, do we still continue to report? What is our liability in these cases?
Absolutely continue to, if APS closes it or says there's nothing we can do, then the next alternative would be to go to the police report and file it there, or it can go to, if it's a situation where you feel the person needs a guardian, it can be a referral to the Public Fiduciary's office also.
Steve Thompson states and asks, so we have policies that prohibit employees from visiting or socializing with clients, quote unquote, off the clock. So if they're not scheduled in our scheduling software, that's off the clock. Does this protect us at all if something does go wrong?
Yes, if you are training your employees and they're signing something that says it is against policy to fraternize, so to speak, with clients off the clock, then yes, that does protect the company. But if she shows up and she's telling the family, "Hi, I'm here for my shift," and she's representing to them, then you need to make sure that you're documenting that when they show up to say, "See, we have this paper that says she was not working," and then it's on her as a misrepresentation.
Does anybody else have any other questions? That was it for the group chat. All right. Steve, are you doing any closing remarks, or Zach?
Yes, I'll go ahead and close this out. First of all, Toni, thank you very much. This is very informative. I think this is very valuable information, and I think we appreciate the fact that you're available to potentially do other trainings, because I think as much as we all put policies and procedures in place and practices to handle situations like this, it's difficult, and it's probably something we can always use continuing learning on. So thank you very much. And for all of our participants, thank you for joining us again for our fourth in the presentation series. And just a reminder that our next series will be on Tuesday, November 10th, starting at 1 p.m. And our next session, the speaker will be Angelo Spinola from the law firm of Littler Mendelson, and he will be speaking about Arizona legal and federal updates regarding everybody's favorite topic, COVID-19. And we will be sending details by email as we go forward, and we look forward to seeing you on November 10th. Thank you again for your attendance, and wish everybody a nice day and good rest of your day, a good rest of your week. And again, thank you, Toni, very much. Appreciate it.
Thank you, everybody. I'm going to stop us now.